And if it's not, we need to tell those congregations clearly, well, you've got to do this X, Y, and Z. On that point, and this I think is significant, it comes out in a number of the submissions to this inquiry, and I should say I haven't read them all, but I've read a lot of them, and I've read some of them at higher and deeper levels than others. But one of the things that came out of the evidence which I read was that the Church of Scientology is going to be able to make sure that it ticks the boxes for public benefit in terms of its commitment to humanitarian activities, or its commitment to drug relief, or its commitment to education, or whatever. So it's there seems to be evidence that it would make sure it fell within the scope of those of public benefit, as whatever this Senate might, or whatever the legislation might require. And that comes out in the what I'll call the Scientology case, the case of the New Faith, the Church of the New Faith and the payroll tax in Victoria case. Can I therefore take you, Senators, where I think that the debate really should go on this, and that's not about what the heart of it is, but where the boundary is, which really is a different way of stating what Senator Cameron was asking before about, aren't I setting the bar very high? It's about when do we exclude organisations. So we shouldn't be saying when are we at the centre of the inquiry of what's public benefit, but what is not public benefit. And so we work on a definition of exclusion. And there's some cases on that point, and the common law has already done that. It said, no, if we're not, if it's for private benefit, for example, it's excluded. If it's for illegal purposes, it's excluded. If it's for purposes that are completely antithetical to religion, generally, it's excluded. So I'm not sure that that's not the right place to focus the bar. And then to follow on from Senator Cameron's point, it's really a matter for public debate as to how high or low we want to set that that bar, Senator, to use your language. The last point is the obligations in relation to reporting that you've raised. Can I say again that I don't think one size fits all, and I think your arguments with respect to the trade union movement, for example, Senator Cameron, are very helpful in this context. And can I just lay out some parameters or frameworks that I think should apply? I think as a general proposition, if an organisation does not seek any income tax exemptions and is happy to pay tax and be a not-for-profit organisation, the level of accountability might be low or nil. I really think that we've got to encourage freedom of association in our society, and that if there are organisations or people that might be fearful of even being known that they're meeting and having to lodge returns, I think that could be, there would be times when it's appropriate not to require those organisations to report at all. And obviously if people are fearful of cult activity, the fact that they are meeting as a group and that their registered office is X and that here is the list of members is the kind of information that they may not want in the public domain. And provided they're willing to fall outside of the net of exemption or deductibility, then I think there's an argument for complete freedom. The second level is that there is an argument to be had about levels of accountability when you're getting tax breaks. Now, what are tax breaks is a matter for debate, but I think there's a debate to be had in that context. The third point that I'd make there, and I picked trade union movements also as frequently non-profit exempt kinds of organisations that are associations of people for non-commercial purposes, shall I put it like that. So they fall within the scope of potentially this sector that we're talking about. And the general proposition should be that the regulation should be as low as possible to encourage and facilitate free association. And then you say we regulate because it will encourage free and voluntary association. So where there's fundraising, for example, raising funds from the public, we might want a structure around that to give public trust. But we shouldn't simply be introducing legislation and regulation because we can introduce legislation and regulation. It all must be purposive and proportional would be the kind of propositions that I'd start from at a principles level. They're the issues that I picked up out of Senator Cameron's questions and my responses to them by way of introduction. I'm happy to take any of them further if that's helpful.
I've just got one last question before we move to Senator Xenophon. And does your Newman and Turnour, do you carry out work for charities?
Yes.
Is that a significant part of your legal work?
It's a significant part of my personal practice, and it's a We have a fairly broad practice, Senator, in answer to your question, but I have experience in acting for a number of charities personally, yes.
So you've got a vested interest in this, have you?
Senator, the cynic would say I have a vested interest in a whole lot of grief, because the more grief there is, the more likely I am to be retained. In sorting out the grief, that would be probably a lawyer's kind of answer to that question. But if you're saying do I have a vested interest in it, I've been actively involved in not-for-profit organisations since my adolescent years, and that would be where my passion comes from.
Yeah. Because I'm just looking at this. We've had other submissions from consultants, consultants to the charities industry, if you want to use it crudely, the term crudely. And if there's a charities commission established, a lot of the requirement for external expert legal and consultative advice might disappear. I just spoke against my interest in at the outset, didn't I, Senator? Because I said at the outset that I think a commission, as recommended by this committee last year, is in the best interests of the country. And I've come at this from a number of angles. I think we could develop the Attorney General's role. There are other things that could be done, but ultimately I think a body separate from government and the tax department is prudent. Thanks for that.
Senator Xenophon.
Dr. Turner and Professor Lowndes, if he wants to chip in, I'm happy for that. Dr. Turner, in your submission you argue that a public benefit is a conceptually difficult concept. The way it's evolved with the Charities Commission in the UK prior to the codification of a public benefit test in 2006, and also the way it is evolving in New Zealand with their Charities Commission, it doesn't seem to have caused at a practical level the difficulties that seem implicit in your submission.
That might be, Senator. First of all, Senator, I think it's a little early to say. The UK Charities Commission came in 2006. Sorry, the legislation came in 2006, and I've said already.
But the Charities Commission has been around for much longer.
Myles could give you the year probably. I can't remember. It's been around a long time, hasn't it, Myles? How far would you go back?
The 1860s.
Yeah. And probably before that, you go back to the statute of limitations, and those commissioners first commissioned.
So,
the conceptual difficulties of these, Senator, that under the common law we had 4 heads of charities driven from Pemsl's case, or gathered into 4 heads of advancement of religion, advancement of education, the relief of poverty and essentially welfare-related things, and other purposes for the public benefit. And the case law struggled. The judges frequently wrote difficulties about saying what level of public benefit is required to satisfy this, and they made a decision on the particular issue. I'm not sure that there's been a huge difference in the context of religion, at least, from moving from the common law position as a result of the addition of many other heads of charity, because the Charities Commission is now dealing with 13 heads of charity in the UK, and what level of public benefit is required to satisfy each of these heads is the real issue. And I'm saying that in the context at least of religion, which is what we're focused on here, I think that's quite a difficult area to define when a religion does and does not satisfy the public benefit if you use a positive as distinct from a negative test.
you don't see more safeguards of the UK test where it says that before that there is no presumption of a public benefit for a religion. It just has to show that, but it doesn't seem, the sky hasn't fallen in. Organisations continue to get the tax-free status by virtue of being a religion. It doesn't seem to be that onerous in practical application.
But I don't think the law has particularly changed that much, is my contention. I'm not sure, is what I'm saying, that when all this is done, I'm not sure that we really haven't got much beyond the common law position.
So the codification in 2006 is more of a tweaking. It's more of a, the threshold is still there. It's just that it's seen that you just show the public benefit rather than presuming the public benefit, but that doesn't seem to be onerous in a practical sense, does it?
Myles, you might be able to answer this better than I can, but my impression is that there hasn't been much change because of the ruling that has come out more recently in relation to that the December 2008 ruling that came out of the Charities Commission. But why pass the law if there is not any significant or substantive change. And what I'm arguing for, as best I can see it conceptually at the moment, is to argue for the negative. That is that as soon as an organisation looks like it's not actually for the advancement of religion, you put it on test to prove that it is, and that it's not for a purpose which is not charitable.